Now we'll spend some time talking about the 3 stages of the arbitration process that happen after the arbitrator is appointed but before the award is issued. Perhaps the second most important thing next to the award is the preliminary hearing. This is a critical management step. In some of your other readings, you will get into much more detail about why this is so important. Many, many years ago, this might not even have been done, but because of the concerns that arbitration has become too much like litigation and too expensive and can go on and on and on with no controls, arbitrators are not only expected to be the decision makers, but they're supposed to be the process managers, and this is where that management starts and sets the tone for the rest of the hearing and throughout the remainder of the arbitration. The details of a preliminary hearing may vary depending upon the type of case and the rules that govern. Some arbitrators have an agenda that they will send out in advance so that the parties come prepared, or they may solicit agenda items from the parties so that the arbitrator knows if there are any other preliminary issues out there that might be addressed. It's not effective for anyone if preliminary issues are raised by surprise. The preliminary hearing can be conducted in person, on the phone, or through any other technology devices. More complex cases or more contentious cases, it usually is done in person. The preliminary hearing is usually the arbitrator or panel of arbitrators and counsel, although in large complex cases, business executives may attend with their attorneys, so they have a say, and the arbitrator also knows that any agreements of counsel have been reviewed with those clients. There's a list set out here of things that are covered, and the rules of all of the provider organizations also contain guidelines of what may be covered, which may vary depending upon the size and scope of each case. One of the most important things that is done at a preliminary hearing is establish the schedule. Now, this includes the schedule of what happens before the actual hearings, and then, of course, the specific days and times that the hearings are going to take place. Part of scheduling also goes to the biggest pre-hearing issue, which is that of discovery. You'll note that most arbitration rules really only provide for the exchange of information, not the full-blown discovery you would get in court. In larger cases, there is some leeway for the arbitrator to issue subpoenas for deposition of witnesses, may entertain orders from the parties, or entertain requests, more properly, from the parties to take depositions. This is an area where the parties can put a few limits on the arbitrator's authority. You may see an arbitration clause which gives the parties that authority to have depositions as part of the arbitration process and limits the arbitrator's authority to say no, that's going to add time and expense. But the preliminary hearing is a chance to discuss these matters, and sometimes expanded discovery may help for a more efficient hearing. Other times it is, as they say, a fishing expedition, so it is important that there be full and fair disclosure of what everyone needs and why they need it, and in general, unless limited by the parties' arbitration agreement, the arbitrator has very broad authority to establish what shall be exchanged in advance, what may be limited, and whether or not any of the more formal discovery procedures that parties are familiar with from court may be used in arbitration. You'll note the list also includes site visits, which are not uncommon in arbitration. It's important to note that an arbitrator cannot just on his or her own initiative go visit the site. The parties can waive their right to be present, but in general, parties expect to know everything that the arbitrator is seeing or possibly hearing in support of the ultimate decision. So if they're not there to see what the arbitrator sees or to explain it or to refute someone else's representations about what's going on at the site, site visits can be a little bit tricky. So they're often conducted with the parties and party representatives and the arbitrator. And site visits, the need for them, and the logistics will be scheduled at a preliminary hearing. This is also a point to pause and make another critical distinction from mediation. In an arbitration, there is generally no communication between the arbitrator and the parties in counsel outside of a preliminary hearing or the actual hearings. If the parties don't use an administrative service, then obviously they will need to communicate with the arbitrator. But in general, all communication by an arbitrator to the parties is done when all of the parties are present. After the preliminary hearing, the arbitrator generally issues an order which confirms everything that was discussed and includes the schedule of events as was either agreed upon at the prelim or ordered by the arbitrator if everyone could not reach an agreement. That is issued to the parties promptly. And when we talked about scheduling before, we talked about possible check-in dates. If there is a period of time between the preliminary hearing and the actual hearings on the merits, many very good arbitrators will establish some check-in points, and this could be simply directing the case manager to send the parties an email just saying, here's what was due on this date. The parties were supposed to have a meet and confer, or the parties were supposed to exchange certain documents. If that's been done, no need to reply. If it hasn't been done, we need to schedule a call with the arbitrator. This is a very effective way to keep things on schedule, because it's this period of time where parties can start granting extensions to one another, going back to the arbitrator and saying, oh, we just need a few more days, or simply for good or bad reason, not comply with an arbitrator's directives as established at the preliminary hearing, and then you find yourself on the eve of hearing and people aren't ready and the hearings are proposed, and that's a source of time and delay and extra cost. So those check-in points can be very important. They're probably more important, which may be a surprise to some people, on the smaller cases. On the larger cases, parties are going to pay attention. They are going to be more concerned about how they're spending their arbitration dollars. But again, it's a step an arbitrator may put in as a proactive measure and may not be needed to be used at all. Once the preliminary hearing has been concluded and all of the management steps outlined to the parties and information exchanged to the extent any discovery was ordered, that discovery is complete. We move on to the hearings. An arbitration hearing is still a formal process, and there is a certain structure to it, but it is less formal than a court proceeding. Arbitrators do not need to strictly enforce the rules of evidence or the rules of civil procedure. So, for example, some hearsay testimony, which would normally be excluded in court, may come in, and that's usually allowed because it goes to the efficiency of the process. The parties don't have to go out of their way to prove the information by some other means, and a party disputing the validity of that testimony can do so at the hearing, and the arbitrator will be the judge of the credibility. Remember, the parties have chosen arbitration because they wanted some control over who hears the case, and they hopefully have selected people with expertise not only in the hearing process, and if you're using any of the providers, remember that their neutrals have gone through extensive training and an extensive recruitment process. So they will have process expertise, but they also will have enough experience in the industry and their field to know when testimony is credible or not. And again, through the adversarial process of the lawyers, credible testimony or challenges to it can be brought forth. Most often the claimant goes first, followed by the respondent. In multi-party cases, claims may be grouped together for efficiency's sake. Another efficiency tool that has been used in larger cases in recent years is what's called a witness panel. This is done with expert witnesses, not fact witnesses, and instead of the party proposing the evidence, putting on one witness, the other side cross-examining, and then the next expert goes, and etc., all of the experts on a particular issue make a single presentation. And it's not that they get together and agree on it, but expert for the claimant will make a presentation, expert for the respondent will respond to it, and counsel and the arbitrators can question the witness panel. It is more effective sometimes than putting them on in the traditional one after another manner. Some other things that may come up at hearings, the first one is bifurcation. This actually might be affected at the preliminary hearing. Where you see it most often is where there's an issue of liability, which is heard first. If the arbitrators find that there is no liability, then there's no need to have further proceedings on what the damages are. And obviously, if there is liability, then the case will proceed to a damages hearing. And an ex parte hearing is where the arbitrator does have a meeting with just one side. It is still the formal hearing. The party who is present must still prove his or her case. That party does not win by default. But if after due and proper notice a party fails to appear, that can't be used as a reason for delay. The arbitrators do have the authority under the rules to proceed in the absence of a party, provided that that party has received notice. Once the hearings have concluded, the next step or stage in the process is called closing the hearing. This may not be directly at the close of in-person hearing. Remember, if there are post-hearing briefs, those would be filed at this time, usually in the last day of hearing. The arbitrator will ask the parties again if post-hearing briefs, which may have been ordered at the preliminary hearing, are still necessary. If the answer is yes, the date for those briefs will be established, as well as any page or issue limitations. So it's either the last day of hearing or the date set for receipt of the briefs is the date which is called the close of hearing date. And this is an important date because it establishes the clock for the time to render the award. Either through arbitration rules or the parties' agreement, there's a specified period of time in which the award must be rendered. In the standard arbitration rules of the AAA, it's 30 days from the close of hearing. That's 30 calendar days. Different tracks within the AAA's rules and other provider rules may have different time limits. But if that award is not properly rendered by the established award due date, then that award will probably be declared void. Parties could agree to accept a late award, but in most cases a late award will be a valid source for challenge. Now, once the hearings are closed, there are a few exceptions, and the parties can move, or the arbitrator on his or her own initiative can move to reopen. New evidence might be a reason that hearings are reopened, but the arbitrator has to do a balancing act and consider, is this evidence that is critical to the deciding of the case, and is it evidence that could have been discovered reasonably prior to this time? So the arbitrator does have the power to say, no, I'm not going to reopen the hearing. The arbitrator also cannot reopen the hearing if it will affect the award due date. So that is a review of the 3 stages of arbitration prior to the issuance of the award.